think we're going to get going soon because we were just concerned about well, about losing time. You know, you start to let it slide too much at the beginning and you can never catch up. I mean, I can crunch mine by at least 5 minutes if you'd be right even more. I mean, we can roll over ours if we have to. She's from Kingston. She's from the eastern Kingston.
Oh, so there's Norm.
See what they had to say.
Good morning. How are you?
I'm well. How are you?
Very
These are nice for you.
Great, thank you. Okay.
Excellent. Hey, Norm.
Morning, Norm. Good to
How are
see
you?
ya.
Very well.
Good.
Good to see you. Thanks for coming.
You won't be seeing Gene, unfortunately. He's leaving the house this morning. So don't bother me. I'll say a few comments and part one.
That takes precedence. That takes precedence. That's
That's
more.
We'll
Come on,
argue
Norm.
about that later.
Yeah, all right. Norm, would you join us at this table?
Can I do that? So
Yeah.
that we're
Absolutely.
Sure,
Wonderful.
that'd be great. If that's the case, we're gonna why don't I have Sarah come up and sit you to get her up and I can just take a quick look to see if Madeleine and Adam are here. I'm just gonna check if everything's all set up and how much you'd like to get started.
Yes, please.
Well, yeah.
Thanks for your emails, Norm.
Well, the other
Flurry of activity.
You'll be able to do it today, you think? Or
I hope so. Well, I think Reisman and Reddy are done, and I think we may be waiting for Sarah to sign off. Yeah, corner, that's right. Yeah, you can't leave until.
Don't be too sure. Oh, is this when you twist his arm about getting that certificate?
That's another story.
So the guy making funny faces at you? That'll be
On TV.
to make faces.
You're actually on TV. They're being broadcast.
Should be interesting day. How are things? These are looking good. Yes. When do we get
My name is Annette Franks. I'm counsel for the Professional Development Program at Osgood. I would like to thank you for attending today's program, Ontario's new brownfields law, what it means to you and your clients. Welcome to those attending in our Toronto office, here, our Toronto Lecture Hall, as well as to those attending at our ILN sites across Ontario. There are a few announcements. For those of you with cell phones, we please ask that you turn them off or that you turn them to silent mode. With respect to our ILN sites, please check off your name on the sign-in sheet. With respect to our materials, tab 2, James Flegel and Norman Rankin's paper will be distributed to you after the program. Tab 3, has already been provided to you today, separate from the materials. For those of you at our ILN site, it will be posted on our website. With respect to our course evaluations, located in your binder, you'll find a gray form. It's really important that you fill that out in order to allow us to continue to develop our program and offer the best programs for you. If you're in the Toronto Lecture Hall, please drop it off in the box outside the hall. And if you're at our ILN site, we ask that you please return it via fax or mail it back to us at your earliest convenience. One brief note on videotaping. This program is being videotaped, and for those of you in the audience in Toronto, your image may be captured on tape as well as your voice. With respect to questions, there will be a 30-minute question and answer period at the end of the program. There is a sheet at the back of your binder, a lined piece of paper for questions. For those of you in Toronto, please fill out that sheet and drop it off at the in our question box, and it will be directed to the appropriate speaker. For those of you at our ILN sites, please press *22 on your phone panel, and that will notify our keyboard that you have a question. I'm pleased at this point to introduce our two program chairs, Alexandra Pike and Marc McAree. Alexandra Pike is a partner practicing environmental law at the Davies Toronto office. She's a member of the executive of the environmental law section of the OBA. She has extensive background in planning law and experience in the purchase and redevelopment of brownfield properties. Marc McAree is an environmental law specialist, and he's a partner at Williams & Shier, Environmental Lawyers, LLP. He's an active member of the OBA Environmental Law Section, the Environmental Committee of Toronto Construction Association, and the Environmental Committee of the Automobile Parts Manufacturers Association. He's also a course instructor with the Ontario Real Estate Association, and he will be teaching environmental law and brownfields legislation as part of the Professional Engineers Continuing Education Program at Ryerson. Enjoy today's program, and at this point, I will turn the microphone over to Marc.
Well, good morning. Annette, thank you very much for your most warm welcome this morning. We're very pleased, Alex, Pike, and I, to have put together an excellent faculty on Ontario's new brownfields law. We have lots of ground to cover this morning, and we hope to hear each presentation in its entirety, preferably and hopefully without interruption. What I would ask all of you folks in the audience to do is to write down your questions, hold them for presentation during our question and answer period during our panel session at the end of the course. And we will, in fact, take questions from the Toronto venue and also our linked outside of Toronto venues. I thought what I would do is just spend a very few minutes introducing the topic of brownfields. And some of you may be asking, so what is a brownfield? And my response to that is that if you go on the internet, there is literally a plethora of definitions for your viewing pleasure. And I thought what I would do is provide you just two definitions this morning to kickstart us. From the Ministry of the Environment's website, the Ministry of the Environment defines brownfield as brownfields are lands on which industrial or commercial activity took place in the past and that may need to be cleaned up before they can be redeveloped. In reference to the US EPA site, there is an online glossary on the US EPA website, and the US EPA defines brownfield site to mean real property, the expansion, redevelopment, or reuse of which may be complicated by the presence or potential presence of a hazardous substance, pollutant, or contaminant. I think there are three identifying features of brownfields. First, the property has been contaminated by past uses. Second, individuals or institutions are interested in redeveloping the land. Third, the contamination must be cleaned up as a precondition of redevelopment. The province is hopeful that the brownfields law will encourage the redevelopment of brownfields in urban areas, and I suggest specifically in the core areas of urban areas. In fact, the long title to Bill 56 incorporates this notion. It states an act to encourage the revitalization of contaminated land and to make other amendments relating to environmental matters. The Brownfield Statute Law Amendment Act 2001 was introduced in into law in November of 2001. And the statute itself amends a number of other statutes, including the Environmental Protection Act, the Municipal Act, the Municipal Tax Sales Act, the Ontario Water Resources Act, Pesticides Act, Planning Act, and Education Act. The Brownfields legislation has and will become law in 3 stages. First, portions of the Act that provide limited liability protection for municipalities, secured creditors, receivers, trustees in bankruptcy, and others came into legal effect in December 2002. Second, Ontario Regulation 15304, the Record of Site Condition Regulation, came into legal effect on October 1, 2004. And finally, we anticipate in year 2005 that the ministry will bring into legal force and effect provisions relating to the mandatory filing of records of site condition where there is an actual change of use of property. For the first time in Ontario, we have a codified legislative regime or framework for site assessments and cleanups. Specifically, the new framework does a number of things. One, it sets standards for individuals who are authorized to undertake property assessments, cleanups, and risk assessments. The new framework also certifies these individuals as qualified persons. It sets out regulatory standards for certain contaminants. It establishes regulatory standards for undertaking Phase 1 and Phase 2 environmental site assessments and risk assessments. The new framework also provides a mechanism for the ministry to do a number of things. First, the ministry can acknowledge records of site condition. The ministry will also maintain a public, internet-accessible environmental site registry for the filing of records of site condition and related documents. The ministry will accept risk assessments, and the ministry can require the registration on title of a certificate of property use to enforce conditions to minimize risk of contamination when that contamination is left on site. The new framework also provides for limited liability protection following the filing of a record of site condition, and it sets out, as I've mentioned briefly, a mandatory record of site condition filing requirement where there is a change of use of property. So these are the topics that we are going to do our very best to digest over the next 3 hours and 45 minutes. And at this stage, I'm going to move on to point out one reference item in your binder. And at tab 9 of your binder, you should find a glossary of terms that my colleague Barry Spiegel and I put together. The list at tab 9 is not all-inclusive. For more definitions, you can refer to Ontario Regulation 15304, subsection 1, sub 1. And I also mentioned that there are other definitions that are interspersed throughout the Brownfields legislation. On that note, I'd like to introduce my co-chair, Alexandra Pike, and Alex is going to start us off with a discussion of emerging land use planning and development initiatives from the province that focus on intensification of development and in turn, I suggest, will promote the redevelopment of brownfields.
Good morning, everyone. We are running a little behind schedule. I think that there's been train problems this morning. So we're going to move through this segment quite quickly, and then you'll get to hear the real nuts and bolts of the new legislation. But let me just point out that there are proposals to Ontario's planning regime that could make very significant changes in terms of supporting brownfields redevelopment. So it's a very exciting time from that standpoint. None of these proposals have been implemented yet. We still have to see how they come forward. But I think there's enough indication of some real support for brownfields that the momentum is going to be there alongside these new brownfields amendments to bring about some real change. And hopefully the clients that you have that have brownfields will be coming to you to talk about how to take advantage of the amendments and perhaps also some of the new changes to the planning regimes. The few things that I can point out to you are the Greenbelt protection that we've heard spoken of so often. The Greenbelt Protection Act went into place, imposed a moratorium on the expansion of urban areas so that the Greenbelt Task Force could consider how to protect green space in the Golden Horseshoe. They've put their plan forward, their recommendations are with the government, and now it's up to the government to actually put a Greenbelt plan in place. The recommendations are to, in addition to the lands that you would expect to have part of a Greenbelt, like Oak Ridges Moraine, the Niagara Escarpment, the Holland Marsh, Niagara's Tenderfruit, and grapelands. They're proposing linkages between green spaces. They're proposing that significant wetlands be included. So we're talking about green space at various scales being included in a protection plan. The other recommendation of the task force that's noteworthy is the fact that they had asked that it be municipalities that implement this plan. That's very different from what we've seen in the Niagara Escarpment with the use of that plan. And I think that time and again you'll see that the planning proposals are focusing on moving the decision-making in terms of land use planning in this province squarely with the municipalities. And if these proposals are in fact implemented, that's where we'll be looking for brownfields initiatives. What dovetails with the Greenbelt protection is the growth plan. And the Ministry of Public Infrastructure Renewal put together a proposed growth plan this summer. This was to address the monumental population increase that they're seeing over the next 25 years, primarily in the Golden Horseshoe in Ontario, but they actually go beyond and call it the Greater Golden Horseshoe. It spans from Niagara through the GTA and to the east, but they've also added Peterborough, they've added Barrie, they've added Kitchener-Waterloo, Cambridge. They're calling this the Greater Golden Horseshoe. They're saying we're going to have another 4 million people come into this area within the next 25 years. And what they're saying is that this is going to make this area the third most populated region in all of North America. So obviously the planning decisions that are going to be made within the rest of our careers are going to be very significant in terms of accommodating this kind of growth. And what they specifically outline is that our environment, our green space, our agricultural lands have to be a priority in accommodating this growth. We cannot bulldoze over more green fields. And in turn, they look at urban intensification. And that's the key to the brownfields redevelopment, is seeing the emphasis on urban intensification so clearly put forth and dovetailing that with the Greenbelt protection. I think that these two plans that are expected to come forth this fall will tell us a lot about what the province has in mind for brownfields development. The proposed growth plan did specifically mention brownfields redevelopment as a key opportunity for urban intensification. And it went even further to say that steps have to be taken to reduce the barriers to brownfields redevelopment. And it specifically noted did, access to financing. I talked about front-end financing, talked about mortgage financing, talked about taxes. So when you see those kind of specifics put in something that's a proposal, we're hoping that we're going to see some real teeth to the growth plan as it comes forward this fall. And I think that regardless, we're going to see some strong statements in support of brownfields redevelopment. A few other noteworthy tidbits. Bill 26, which is through second reading and amendments at committee, has proposed a change to the Planning Act that would eliminate the right of appeal that an applicant would have if they were proposing expansion of an urban area, existing urban boundaries, or new urban areas, and the municipality had not supported the application. So Bill 26 would basically say if the municipality is not on with what you want to do to the urban area in that municipality, you're done. You don't have the route available to you to go to the OMB. What would come to the courts in that kind of circumstance, we can query, but the OMB has been the route for developers in greenfields looking to expand urban boundaries, and they're looking to shut that down. So that's another key change. We also see changes to provincial policy statements where there have been comments about the benefits of brownfields redevelopment, but what we're seeing is a shift to say that brownfields redevelopment should go ahead in advance of greenfields. Now, there's a big qualifier in that. It says where possible. That's the proposed language to the change for the provincial policy statement. Where possible, brownfields redevelopment should go ahead in advance of greenfields. We will have lots of fun interpreting that where possible comment, but at least we're moving to a situation where brownfields are going to take a significant role. They're going to be seen as a real option, and we won't be turning to greenfields at infinitum. Marc's going to talk a little bit about the mandatory land use, and we have a couple brief comments on municipalities after that.
Thanks very much, Alex. I'd just like to pick up on the theme of emphasis on municipalities and the municipalities' role in brownfields redevelopment. One aspect of the new brownfields law that will be far-reaching for certain is this notion that where there is to be a change of use from a more sensitive to a less sensitive land use, there will be an obligation on the part of that individual who is, in fact, the proponent behind the use, to file a record of site condition that will be publicly posted on the environmental site registry. And all of that needs to be done with some exceptions prior to the issuance of a building permit by the chief building official of the municipality. If you check e-laws under the Environmental Protection Act, you'll in fact find that this section that I'm talking about, 168.3.1 of the Environmental Protection Act, is still in gray. And again, just by way of emphasis, the reason for that is that it's not yet in legal force and effect. And we're waiting for that and expecting that to occur, I understand, in 2005. And perhaps Norman Rankin from the ministry might have some comment on that. So what does this mean? Well, it means that soon cleanups and the documentation of cleanups, where there is a change of use, will require that a mandatory record of site condition be filed. And I think this is going to be your first lawyer claims prevention tip of the day. And that is that notwithstanding that this part of the legislation is not yet in legal force and effect, I believe quite strongly that lawyers and others in the environmental, I'll call it consulting business, need to be advising their clients now about this upcoming change. And the reason for that is that developments and redevelopments and cleanups don't happen overnight. And it may well be the case that your client or my client is in the midst of a cleanup now where the filing of a record of site condition to the ministry is a voluntary mechanism, and in fact that cleanup may be completed after this part of the legislation becomes in force and effect. Then the question becomes, what obligation did any of us have to advise that client now about what's coming down the pipe? In terms of this notion of less sensitive to more sensitive, the Ontario Regulation 15304 sets out 7 types of land uses. And the 7 types of land uses are industrial, commercial, institutional, community, residential, parkland, agricultural, and other. And I suggest for definitions of these land uses, you turn to section 1 sub 1 of Ontario Regulation 15304. They are defined. A couple of other sections of note coming out of Regulation 15304. Section 2 of the regulation states that where a property has been used for more than one type of use, the applicable cleanup standard will be the one for the most sensitive use. So where you have a property that is used in part for, say, commercial and in part for residential, the most sensitive use, residential, will in fact the property will be deemed to be a residential use. Section 3 of Ontario Regulation 15304 says that vacant properties, example, abandoned industrial sites, will be deemed to have the most recent former use. So an abandoned industrial site today, or at least once this provision of the regulation is in force and effect, will be deemed to be industrial. So I think that this change is going to have widespread impact on the redevelopment of property. I think that, again, this notion of a voluntary record of site condition to the ministry being converted into a mandatory requirement where there's a change of use is going to take the choice away. And one implication of that, and it's something for all of us to think about in the context of addressing our clients' concerns or situations, is what is the effect of this record of site condition being filed on the public registry, the environmental site registry. And one of the issues that comes to my mind is whether in fact that very act of making public the cleanup of a property is in and of itself going to stigmatize that property. To what extent is that property going to be more marketable or less marketable? And I think that's a big question mark, and it's going to be a concern for our clients. Another concern, I think, arises for municipalities. Municipalities these days are, not all of them certainly, are equipped to assess environmental issues. Certainly building departments at some of our smaller and perhaps medium-sized municipalities are going to be struggling with this notion of other applicable law and the requirement to obtain a record of site condition before the chief building official is permitted to issue the building permit. So those are just a number of issues. Alex, I'll turn it back over to you to finish us off. Thank you.
Thanks, Marc. Marc's last comment about municipalities leads into my last comment in this area. When you're looking at how the new brownfields amendments tie in with provincial planning, look to the municipal level. That's where we're going to see various factors in this legislation implemented in a way where your clients will get some of the benefits. We will see the liability protection at the provincial level, but where we're going to see the tax benefits, where we're going to see the grants that are available is going to be at the municipal level. So don't forget about that, and you'll hear more about that a little bit later from Michael Kovacevic. But we've already seen some municipalities jump ahead of this legislation. You look at Hamilton and you look at Kitchener, and those are municipalities that take their brownfields very seriously and want to see those properties redeveloped. It's key to their urban success. And they've had community improvement plans in place that effectively reflect the legislation long before the legislation was in place. And those tax incentives were in place and working. And those grants for investigation protections were in place and working, and we now see many other municipalities considering moving ahead. I know Kitchener has their CIP in the drawer ready to go. Another area that you have to focus on at the municipal level is how clear is the planning process at the municipality. Just because we now have these amendments which are talking about the liability protections at the municipal level doesn't make it all that clear how your client is going to get through to actually getting building permits. How is this going to affect their process in terms of OPAs, zoning bylaw amendments? And what we would suggest is that you keep a very close eye on municipalities and what they're doing over the course of the next year, because they're waiting to see how these brownfields amendments are going to work in practice. What we have seen, for instance, in Toronto, following the passage of these amendments, but before they came in force, the City of Toronto was grappling with their amalgamation realities, and they came up with a harmonized process that was supposed to make their contaminated lands redevelopment process clear. And I think it certainly provided a lot of guidance. It includes a requirement for an RSC or an approved SSRA. It includes a peer review. And that was a process that was turned to by development clients over the last couple of years. The city now has to reconsider what it needs in that policy, whether it can rely on what the province is now requiring in terms of mandatory, what will not be provided in terms of the voluntary registrations under the brownfields amendments. Will the municipality have to make up for that in some respect in its planning process? So there's a lot to keep your eye out on at the municipal level, both in terms of the benefits, in terms of incentives and grants, and also in terms of the planning process. So that wraps up our planning introduction and the elements that come into play between the amendments and how they're actually going to work in terms of a redevelopment approach. But for the rest of the day, we're really going to open up the amendments, look at them in a lot of detail so that you can understand exactly what was intended, where the question marks still are, where there's lots of work to figure out how this is going to operate in practice. And the first person to come and join us today is Norman Rankin. And I'll come up to the main mic up here. Will you speak from here? Okay, great. Norm is Senior Counsel at the Ontario Ministry of the Attorney General. He's on assignment Regional Counsel for the Ministry of the Environment. He does work for Toronto, Halton Peel, and York Durham. Norm has had significant experience in the environmental field, both in private practice and now for the government, and has been involved while these brownfields amendments have been prepared and in their rollout. And he's going to talk to us about the various expectations that people had for these amendments, because as you might expect, there were a lot of stakeholders interested. The development community, municipalities, are two of the key groups that were interested in this legislation. The ministry had a lot to balance in their drafting, and you'll see what their objectives were and what they think they've come out with. So Norm, thanks for coming.
Good morning, everyone. My colleague Jamie Flagle sends his regrets that he's not able to join us this morning. Many of you may know that Jamie is actually the one who was very much involved in the development of the legislation. He's our policy and legislative guru. I'm more on the practical implementation side. But although you won't see Jamie and hear his golden tones, I have had the benefit of working with him on this presentation, and we've actually wanted to do something a little bit different than what you just explained. We want to give you MOE's top 10 list of the key changes and initiatives, and more or less set the stage for the speakers that will follow. We will, as was indicated, put together a paper after the program, which will outline what I'm going to say, and we'll also comment on what some of the other speakers say and maybe answer some of the questions that come up. Jamie will be spending the morning thinking about us, but briefing the minister on some new and exciting complex development that you'll hear more about shortly, I'm sure, as well. First tip, where to go for information? Well, there's one main place to go, and that is the ministry's website, www.ene.gov.on.ca. If you open up the home page, you'll see on the left-hand side a logo for brownfields development. And if you click on that, everything you'd ever wanted to know about brownfields development is going to be there or linked to there. In tab 6 of your materials, Donna's paper, she has included many of the documents that are part of this framework, as Marc called it. There's the legislation and the regulation. There's technical documents that Donna's going to talk about. There are also a number of other materials, sort of guidance materials, presentations that have been made. And in fact, Donna doesn't refer to the one that was most recently just put on, and that's a 57-page sort of client-friendly document entitled A Guide to Site Assessment, the Cleanup of Brownfield Sites, and the Filing of Records of Site Condition. And it's the first of 3 such guidance documents. 2 more are on the way and will soon be posted. One is to deal with the guidance for the conducting of environmental site assessments, phase 2 site assessments in Ontario, and the third one is procedures for use in risk assessments. So that is the best place to go, the ministry's website. A number of documents are referred to, incorporated by reference in the legislation and the regulations, and so it's important to actually go to these base documents and have an understanding of what is there. The website's also the key access point for the second tip, or the second topic, and that is the new Brownfields Environmental Site Registry that Marc referred to. The registry will have 2 functions. First of all, as Marc suggested, it is the public access point where you can go and do a search to see what is registered. And it's going to be user-friendly, that you can search as narrowly as your specific property, or you can search as broadly as you want a municipality, and it'll kick out the information that is registered. Second function that it has, though, is it is the basis where the qualified persons will go to become registered. And so far we've had over 10 people submit applications to be registered as qualified persons. They have to provide credentials about themselves, their experience, their education, their insurance provisions. And once all of that has been verified, they will be given a number and a password, and they then can go into the registry and make the new registrations. They will draft the records of site condition on the site. And that is a change of process from what we've now been used to. The regime we've been used to since 1996 has been that there have been a paper document that's been filed, and it's been filed to the district office of where the property is located. And it's been sort of checked off by the local district officer, who makes sure that the document was filled out correctly and all the pieces of paper were there. And if there was a risk assessment, it would be sent downtown to be dealt with by Standards Development Branch, and the 2 of them would work together. Now this function is going to be centered at Approvals Branch, and they look after the registry. And the registration needs to be done electronically, and the qualified persons will draft it. It's a simple thing. It's like us getting a ticket from an airline. It has boxes and drawdowns, and so they will be completing that. Unfortunately, so far on the website, there isn't an example of what an RSC will look like, but I'm pushing to get various samples of records of site condition, be it one that's filed with just a phase 1 site assessment, or one which is just a straightforward phase 2, or one with a more complicated risk assessment. So that's something that you'll have to wait and see as well. You won't be surprised if you go to the website to see that there is a 1.5-page disclaimer for Brownfields Environmental Site Registry, and it has the typical paragraphs that, of course, anything that's on the website is not advice, and you better hire a lawyer to get you good advice. Secondly, there is this interesting paragraph that I think is factual as well as interesting. The information on this website has been submitted by persons other than the MOE. The MOE cannot and does not guarantee that the information on the website is current, accurate, complete, or free of viruses, errors, or other items of any kind that are of a destructive nature. And then, of course, there's in big capital letters a no liability, 2 paragraphs that says we have no liability for anything that's on there as well. This isn't really surprising. I think you all have seen the same sort of thing on other websites. And it's not surprising because that is the way the ministry has been doing business in the brownfield areas since 1996, when the guideline came into play. Marc didn't talk about the policy history and where we've evolved from, so let me take a minute to do that. In 1989 was the first time that we ever had a document that was talked about decommissioning or guidelines or cleanup of sites in Ontario, and that was pretty rudimentary actually. And at that point in time, there were a few standards or cleanup guidelines that were proposed, and you had to work carefully with the district office. And in fact, we reviewed all the reports and we commented on your proposed plan, and that just didn't work. Obviously, we were just bogged down and didn't have the resources or the expertise necessary to do that. So over a period of time in 1996, the guideline came into play, and this concept of a record of site condition and a risk assessment came into play. One of the main impetuses for the Brownfields Statute Law Amendment Act in 2001 that Marc referred to were the amendments in 1990 that were made to the Environmental Protection Act that really expanded for the MOE the persons who they could hold responsible for contaminated sites. And that was now anyone not only who is a present owner, but a previous owner, not only a present occupier, but someone who was in occupation before, as well as anyone who now had charge, management, or control of a property. So with that broad scope of ambit under our orders, there are all sorts of questions of what does this mean? When does the liability attach? And how can I resolve this liability? And so the limited liability protection provisions that came out of the 2001 statute and came in force in 2002 really addressed many of those aspects, and we'll hear more about that later on. The Brownfields Statute Law Amendment Act was broader, as Marc says, dealt with a number of statutes other than the environmental ones. I won't repeat those. They're in the papers. Let me now talk about the new way of doing things by the ministry and the new structures and procedures that we've got. I've touched on it already. And I think the ministry has been criticized in the past for getting out of the business of being in charge. But frankly, it's not the way that we can do business nowadays. And so it is proponent driven, and market forces will be the driving force of this whole regime. But as Marc did explain, and hopefully you'll agree when you hear the other speakers, I think we've come a long way to improve the system, because in this new framework, as Marc called it, they are the clear standards that are set out in the regulation. They're basically the same as what's in the guideline, except they've now got the force of a regulation, and they're now called standards as opposed to criteria. They're exactly the same except for one area, and that's petroleum hydrocarbon contaminants. The standards that we had before for total petroleum hydrocarbons have been replaced by what the Canadian Council of Ministers of the Environment have recommended be used across Canada. So there are 4 factions of hydrocarbons that are now have standards attributed to them. One thing that the regulation says is that a QP has to ensure that there is no evidence of free product, and that the groundwater is free from not only objectionable petroleum hydrocarbon odor, but also taste. There hasn't been a guidance document prepared yet as to how the QP is supposed to satisfy that, but stay tuned, maybe we'll get a tip there. But that leads to the next point, and that is the whole aspect of qualified persons that's going to be dealt with is now specifically outlined in some detail. And my first practice tip of the day is, obviously, as is, I think, always been the case, the first thing that you should do for yourself and for your client is to make sure you have a good qualified consultant on board who knows what he's doing, has been there before, has the experience, has the credibility, and you can rely on his advice both technically and strategically. The next thing is how does the QP go about doing the standards of assessment? And the regulation does something which is a little bit different. It actually incorporates by reference the Canadian Standards 2 documents, Phase 1 and Phase 2 site assessments, with one exception. And that is, with those 2 documents, it did have as a limiting condition that the writer could say that unfortunately wasn't able to get access to a certain part of the property or something along those lines, and that's a qualifying condition. Obviously, we as a ministry do not feel that's appropriate in this sort of situation where we're filing a record of site condition. So that means that change is now actually highlighted in the regulation in sections 25 and 31. Interesting question here, though, for you is what happens if it's in the middle of the winter and you need a risk assessment done, or you need a site assessment done? My view would be you're not going to get one done, because how can you do a Phase 1 site assessment if the assessor cannot go and walk the property to see if there's any stained vegetation or any... So that's an area that's going to have to be worked out, I think. But a tip for you to perhaps think about that when you are actually planning a transaction or need to have some documentation. You need to be able to give your site assessors complete access to the property that's involved and the buildings that are involved. Next, we're going to talk about records of site condition in some detail. There's the changes not only to the process that I've described, but also the form has some changes. And one change that came about as a result of requests by the QPs, or more importantly their insurers, was that it doesn't contain this paragraph that you may have seen in the past, paragraph 11 of our former RSC. I acknowledge that public authorities, parties acquiring or intending to acquire an interest in this site, current occupants, and their consultants may rely on the statements in this RSC, and then goes on to qualified. And I see that Sarah's going to comment on that. I think that, and also there is a provision in the regulation that makes it quite clear that the signing of an RSC does not by any means give any guarantees or implied warranties. And what does that mean for us? I think that means if you have a client or you're acting for a municipality, or a municipality wants to rely on the RSC, you're going to have to deal directly with the consultant and have some sort of contractual arrangement in order to do that. So that's going to be an interesting development as well. Next point is, what's the ministry doing to train and get these new procedures? Well, I've explained the website, and there's extensive training going on. My region, Central Region, is the region that has the lead for this area, and so I know that the people aren't in my office. They're busy running around doing some of the last-minute things, and I've explained the sort of areas that the division of responsibility. The point I want to make, though, is for you to get involved in this sort of aspect, the best place to start is with your district office, your district manager, your local environmental officer that you may know for the site. Because although we may not be handling all the paperwork and doing everything, we are going to be involved. We are going to have input as to concerns that we've got about the site or about the area, because the wider area of abatement concerns is something we're going to be commenting on. And if there are risk management measures that are being imposed, we will comment on that as well. And in fact, it will be the director of the region or the district manager that will, in fact, sign the certificate of property use that incorporates those changes. Some of the frustration in the past few years has been the inability for you to meet with people who are actually involved in the file, the risk assessors. And I have a lot of sympathy for that, but I also think you'll understand that we can't meet with everybody. A lot of people aren't well prepared and it would be a waste of time often for people to have meetings. And more importantly, the ministry is not trying to do it all themselves. They've gone out and hired a team of five groups of experts, toxicologists, hydrogeologists, and engineers, to actually help them in processing risk assessments. And so by doing it in writing, by emails, you can then get the information disseminated and get the answers back more efficiently and effectively. That's not to say you can't meet with somebody. Again, I'm going to come back to say, deal with your district manager. We are here to help you. And I also want to digress for a minute and talk about a new initiative that we put in place the last couple of years, and that is we now have people like myself in each of the regions. Regional council are now in each of the 5 regions to help in a number of areas. The Stella Kubin has been in Kingston at the Eastern Region for quite a while. She's been the leader. Brian Burnell is now at West Central in Hamilton. I have the pleasure of being up at Yonge and Finch for the Central Region. Jim Jackson is in London, and although we don't have someone up in the north, we have Claudia Santoro or Nancy Hartree when she's on maternity leave looking after their interests there. We see ourselves as facilitators. Don't hesitate to contact us if you need more information, if you find your clients getting frustrated in dealing with the offices. But by all means, get in touch with us. I did want to talk a little bit about orders and provincial officers' orders, because I know people have said that's the way that the things are being done right now, and that is true. I won't be able to have probably time to say much because of that, other than to say that please consider an order not necessarily something that's bad. It is a controlled document. It's something we want to have on paper, which explains what is expected to be done, how it's to be done, and why. And there is an appeal procedure that we as regional council get involved in to try and facilitate the resolution to that. My 6th point quickly is certificate of property use. This is a new document that we haven't seen before. Let's not confuse it with the old certificate of prohibition. Certificate of property use is the document that replaces the old Section 18 order, which was the order that was issued to incorporate the risk management measures that were part of the old guideline process. There is specific aspects of how that certificate of property use will be done, and it'll be dealt with, I think, by another speaker. One aspect of the regulation I do want to draw to your attention is Section 21. There is a section that talks about soil management practices, and whereas we used to, in the Section 18 orders, in situations where you had a stratified cleanup, the 1.5 meters below the surface were more contaminated than the surface. There was something in the order that said if you ever brought the soil up to the surface, it had to be properly managed and couldn't be left there. That is now specifically in the regulation, so it doesn't need to be in the certificate of property use itself. I did talk about that bad thing that people hated, the certificate of prohibition. That's Section 197 certificates. It's now no longer called a certificate of prohibition. We don't have those anymore. The section has been changed. And as of October 1st, we have certificates. I'm not even sure what they're called. I think they're certificates of requirement, or they're certificates that set out requirements rather than prohibitions. It does the same as what a certificate of prohibition does. It's just it's kinder, gentler, sounds better. Basically what it means is that we could register on title a notice that there is a concern on this land, and you should get a copy of the order or the certificate of property use or the record of site condition. It's a heads up, which now brings another practice point, and that is, I think, as a matter of course, you should be searching not only the title, but you should be searching the registry for information and getting as much information as you can as you go along. Change of use provision was my 8th. I'm not going to say much about that other than to add to what you said, Marc. The 7 classifications of use are not, as you might have thought of, linked to land planning or the Planning Act. They're linked instead to the definitions under the building code because of this link to the building code and the fact that no permit will be issued without the proper registration of the record of site condition. Obviously, you don't need a record of site condition before you do excavation of soil or do shoring or those sort of things. That's an exemption that's particularly set out in Section 12. And in Section 15, there's the exemption that if part of the building already is residential and another part is commercial and you're just changing the commercial area to residential, you don't have to go through the full process there either. The risk assessment is the last area that I really want to talk about and set the scene for future speakers. There is a change, and the changes that have come into play are ones that we hope will make the system work better. And I alluded earlier to the biggest problem that we had, and that was that people were coming to us with improperly prepared documents. So the biggest change is, step 1 in the process is the need to file a PSF. Lost the word, Marc. What is it? It's a pre-submission submission form, and it's consultation between the ministry and the consultant. There is an extensive form that's on the website that has to be set out. Has to set out exactly what is planned. A conceptual site model is going to be established right at the beginning. That's the good news. The bad news is there's no time limit on how long it's going to take to do that, and that may be for obvious reasons. We're not sure how long it garbage in, garbage out, or it may be quick, it may not be. But the intent is to have that early consultation. After that, the regulation sets out timelines for once various types of risk assessment are filed, the timelines for the ministry to get back. It'll be interesting to see how that plays out. One other section I want to highlight for you in Schedule C, which is the schedule that talks about risk assessments, is there is Section 11, which allows us the flexibility, at least in these early years, for the director to exempt certain strict requirements from the regulation and part of the risk assessment process. And that'll lead me to my last point, and that is this a good thing? Will this make a big difference? Will this meet our expectations? I can't tell you. I think it has a lot of benefits to it. I think time is going to tell. I think the points that Alexandra made about the municipalities is key. They are going to be the key players. I know from talking to some of them, they're not ready for this. It's going to take time for them to get organized. They're going to have to figure out how they're going to rely on this system. Is it a good thing to register an RSC? Are people going to do that? It's going to cost a little bit of money, and it's going to take some time and formality. And certainly it does mean that there's a credible system that's there, and you do have some sort of confidence level for the future. And obviously, the key reason for doing it is to get the limited liability protection that people are going to talk about later on today. But I think vendors and purchasers, lenders and municipalities all should be very well advised right up front and early as to what the new system is, and should consider long and hard how best to do it. I hope I've set the scene for the future speakers, and thank you very much for your attention.
Thank you, Norman.
Thanks. Thank you very much, Norm. It will be a kinder, gentler place, I'm sure, and we'll look positively at those orders. And we have, based on that great background that Norm has provided us, now broken up the rest of the day into chunks that talk about specific issues in the amendments. I'm going to turn the mic over now to my partner from Davies Ward, Phillips and Weinberg, Sarah Powell. Sarah is a certified environmental specialist with the Law Society. She has extensive brownfields experience and is going to talk to us today about qualified persons and finding the right person for the job and making sure they do the right job.
Thanks, Alex. I should probably stand because this is so dry. Maybe I could fool you into thinking it was interesting by body movement, but I apologize in advance. It is a bit painful to go through, and I'll try and do it as quickly as possible. What I'd like to focus after I go through the definition of qualified person and flag it for you more than anything. I don't propose to go into detail because it hurts. Once we do that, I did want to talk a little bit about reliance. Norm talked about reliance and the limitations on the record of site condition. I do a lot of work with consultants and getting reliance for one-off to large portfolio deals. It is becoming an increasing battle to work with consultants to get the reliance letter that works in a transaction. I spend a lot of time trying to get the consultants on board to give reliance when we need it to the various transaction parties. And so I want to walk through a little bit my experience recently and the qualifications that we're seeing cropping up, similar to what we've seen for the last decade in the US. And I think from a practice tip perspective, keep it in mind, it's a big deal. And so I'd like to kind of focus on that a bit. But I'll start with what is a qualified person and why does it matter? Norm has already talked about this record of site condition and what it is. At the end of the day, if you're going to be submitting a record of site condition, it has to be done by a qualified person, and I'm going to walk through that. So the definition of what is a qualified person is really important. It starts off pretty easily in the Act by saying a qualified person is defined to mean a person who meets the qualifications prescribed by the regulations. And so that's pretty straightforward, but it goes downhill from there. And I'm just going to work very quickly, and that's not a drafting comment, Norm. It's just it's painful. So we'll go through here. As I said, if a landowner is going to be requiring a record of site condition for whatever reason that they need it, whether it's voluntary or mandatory, they're going to need a qualified person. And a practice tip that you guys can discuss amongst yourselves or at the end of the program is voluntary going to become a fiction? And I think my experience to date is that lenders are going to push for a record of site condition to be filed in the registry. So I think it's going to be a bit of a fiction to say it's voluntary. And I think you're going to see local branches of lending institutions having a little box on their form saying, has a record of site condition been filed? So I think you got to keep in mind that this is over the next year or two. Lenders are going to drive it. And I think lenders have driven much of, over the last decade, the requirements for phase ones and phase twos. Lenders have driven their dislike of risk assessment, and I don't know if anybody has a different experience, but my lenders still don't like risk assessments. I spend a lot of time trying to cajole them into the fact that a risk assessment provides the same protection with respect to risk as generic criteria, but most of them still don't buy it. So as a heads up, if you're trying to move something through with a lender, be cautiously skeptical that a risk assessment is going to work as well for a lender. I'm having an awful time right now with one lender on a site that both Norm and Marc are involved with, and the risk assessment just doesn't fly for them. So keep it in mind from a practice perspective. Lenders are risk-adverse individuals. Any in the room? And so you got to keep in mind that that's going to still be slow. So from a practice tip again, Norm touched on it. Off-title searches, I think, are going to be key from a negligence perspective. Make sure you're looking at the registry, have the clerk set up so it's just a matter of course that they look at the registry. I think if you don't do that and there's something on the registry, it's going to be a liability issue, and I think we really got to keep that in mind over the next year because this is so new. So last on the practice tip before I get into the definitions, Norm touched on it as well. the quality of qualified persons varies. And that's no surprise. But a lot of things that we should do, we don't typically do. And if you do any work in the US, they're much more disciplined about checking references and entering into structured reliance letters, retainer letters. You're seeing that more and more in Canada, the structured retainer letter, which sets out the liabilities, the qualifications, et cetera. I think because of the very important nature of, is this person a qualified person? Can they do what your client needs them to do? You should be thinking about a structured retainer letter to ensure that the person really is a qualified person and can actually, at the end of the day, sign and do what you need to do, whether it's a straight phase one or whether it's a risk assessment. And so the retainer letter is something you should keep in mind as well. So you need a qualified person if you're going to submit a record of site condition, to conduct and supervise a phase one, to conduct and supervise a phase two, and to prepare or supervise a risk assessment. There's essentially 3 levels of qualified persons to conduct either a site assessment or a risk assessment. There's the person who can do the phase one only, then there's a person who can do the phase two with no risk assessment, and then there's a 3rd level of qualified person who can do the risk assessment. The first 2 levels I talked about, the phase one only and the phase two no risk assessment, those are interim qualifications that are set out in the regs. They expire October 1, 2006. Keep that in mind because there is going to be a different certification process that the ministry is currently working on. So at present, for those 2 levels, it's set out in the regs, but that's going to change and there's going to be a very different system for certification. So just something to keep in mind. So again, there's 3 levels. The 1 level risk assessment, that's not going to change in October 2006. And I've set it out in a chart in my speech. I don't propose to go through it because, as I said, it's pretty dry. Risk assessments are complicated beasts. The qualified person definition and educational requirements are set out in detail in the reg. If you're going to prepare or supervise a risk assessment, you have to have a bachelor's degree in science, engineering, or applied technology from a post-secondary institution, and then you have to have certain educational requirements. Again, set out in detail in my speech, but I'm not going to go through them all. But I think you have to keep in mind those qualifications and experience if you want them to do a risk assessment. Another thing you have to keep in mind from a practice perspective, as well as from filing a record of site condition, is the qualified person has to have certain insurance requirements. And Norm's talked about that. It's a minimum of $1 million. And I think that you're going to have to keep that in mind in your retainer letter. If they do confirm they're a qualified person, that they also comply with the insurance requirements under the regulations. They also have to maintain that insurance requirement for 2 years after the date that they've ceased to act in the capacity of a qualified person. So again, keep that in mind in your retainer letter. Are they a qualified person and do they have the insurance that's set out? From a practice perspective, often in big redevelopments that we've been involved with, that $1 million minimum, which most consultants will eventually get to in a retainer letter, is sometimes not enough. If you are involved in a large redevelopment process or in a complicated site, my view is that $1 million is really a minimum, and you should be talking to the consultant about, do you need additional insurance? Do you need to be added as a named insured or an additional insured? And those are all things we do set out in our retainer letters because the insurance issue is very important. So keep that in mind from a practice tip perspective. Is $1 million enough? And if your client's doing something than just a straight phase one, you may want to think about that minimum requirement, and that's going to have to be dealt with in contract in your retainer letter. So again, just something to keep in mind. Norm touched on the final point I want to talk about qualified persons. The record of site condition specifically says that the qualified person, by signing the record of site condition, makes no express or implied warranties or guarantees. And I think most people who I talk to agree that the qualified person is likely protected from that statement by third-party reliance. So I think you have to step back and think about, who do you need, whether it be the municipality, whether it be your lending institution, whether it be one of your joint venture partners. Who do you need to rely on the consultant's reports? And I just think the only time you have leverage is when you retain them. And once you've retained them, you don't have any leverage. So you got to do it up front. And often with the consultants we work with, we either do it through retainer letter or we try and have, and this hasn't been perfect, but a standard retainer that we have with them so that if we're doing one-offs, we know that at a minimum we have this insurance coverage, that they are qualified persons, that they will grant reliance to any lending institution or additional purchaser or subsidiary or successor or sign. So all of those things are really important, and I can tell you it's only getting more difficult to get consultants to give you reliance. In the US, it's a whole different world. You typically cannot get consultants to give reliance unless you're willing to pay. In Canada, it is a kinder, gentler place, and up until very recently, you could simply just phone up the Golders, the CRAs of the world and say, can I get a reliance letter? And that reliance letter would come, and it would be quite straightforward, and there wouldn't be much negotiations. With most of the consultants we're dealing with now, that's not happening. There's lots of negotiations, and when the deal's trying to close and your lender wants it, that's not the time to be having the negotiation. And it's leading, I think, to complexities that we didn't have in the past. So what I'd like to do, if everybody's okay on the qualified person definition, because I think it is set out fairly well, not only in the regs, but in the speech that I provided, the hard copy. What I'd like to just switch to for a few minutes is reliance, and then I'll leave it from there. That, in my speech, is called the push and pull between the qualified person and the client. And I admit right up front that I cribbed most of this from my partner Gray Taylor's article that he did recently, but we'll go from there. I think that you have to keep in mind that Canadian law generally requires that there has to be privacy of contract between the two parties. And I think that nothing in the Brownfields Statute Law Amendment Act changes that general rule. Nothing in the record of site condition provides you with reliance or another party, third party, on reliance on the record of site condition. So vis-a-vis you and the consultant. It may be, and I think some practitioners are worried, and I think Katherine van Rensberg will probably touch on this, some practitioners are worried that the owner, by the very act of filing a record of site condition, is exposing themselves to some form of liability. So that's something that you and your client will have to figure out. But I'm not talking about that. I'm talking about the consultant submits the record of site condition and provides very strong statements that the site is appropriate for use, et cetera. And you'll see in the regulations, I'm sure someone's going to go through it, all of the statements that are provided in a record of site condition. At the end of the day, though, the consultant is saying to all third parties, beware. There's no implied warranties or guarantees. And I think that generally, my gut is that the court's going to say there's no ability for a third party to rely on any statements in the record of site condition. So reliance becomes very important. So I think you have to keep in mind the privacy of contract concept whenever you're dealing with a consultant. I think that you're going to have to, in your retainer letter, and the problem is, I mean, I don't know about your experience, but my experience is the consultant's already been, often the case, has already been retained long before I'm on the scene. And the standard terms and conditions, if you look at them closely, often, and this is why you have to read the small print in these standard terms and conditions, often say that the consultant's liability is limited to the fee. It's a non-starter. Like, first of all, the banks are not going to accept it. And once the consultant's already done the phase one, you can't open it up. You're going to have to either pay for them to open it up or beg. And at closing, begging is just a pain in the ass to beg. So I think that what you want to do is ensure that before anything's signed, you talk to your client about the importance of looking at the retainer letter. And often, consultants will shoot out as a first go that standard limitation. It is not market. If they say it's market, it's not. And it's not acceptable to any lending institution that I've ever worked with. So it is often in the standard terms and conditions, so please, from a practice tip, look at those standard terms and conditions and ensure that it's not sitting there. So that's the one thing I wanted to focus on. I think that one of the most frequent limitation that you see is that the limitations of any reliance letter that's issued, and what typically happens is the report is addressed to X, and it says, X, here's the report, and the record of site condition is submitted. No one else is permitted to rely, as we've talked about, on that report. So what you need to do is typically, before closing, for your lender, for the purchaser, for whomever else is involved in the transaction, you need to get a reliance letter from the consultant saying, okay, you lender may rely on my report and on the record of site condition even, if they're incorporating that. If that's the case, often what the consultants will do is say, yes, you may rely on my report, lender, subject to all the limitations and qualifications in the retainer letter. From a practice tip, the problem is the retainer letters are never attached to the report. They're usually nowhere to be found, and the lender is saying, I won't accept it because of the limitations in the reliance letter. So the easiest thing to do in your retainer letter is to have the power to either have the report addressed to the lender, for example, or often what we do in the back end of the report is say very clearly in the limitation section that although this report is addressed to X, it may be used by any lender in a transaction, any purchaser, however you want to broaden that reliance. But keep in mind, if they're going to limit it to the terms and conditions in the retainer letter, you got to have the retainer letter attached to the reliance letter, or a bank, for example, is not going to accept it. I, as a purchaser, is not going to accept it. And so just one other thing to keep in mind. As I said, it's not infrequently in the standard terms and conditions that the retainer is limited to $50,000 plus a fee, or the fee, as I've said, not acceptable to any lending institution I've worked with, and I just don't think it's appropriate or prudent for your client to accept that, and typically that's a position we take. So keep that in mind again, that's something from a practice tip you got to really keep an eye on. And I think that was about it on reliance. I just wanted to stress that because I think it's very clear now that with respect to the record of site condition, third parties cannot rely on it. And I think it's going to become a significant issue with municipalities and especially lenders, and it's something you got to keep in mind as you go through with working with a qualified person. Done.
Thank you, sir.
I can go.
Thanks very much, Sarah. Some very practical tips from the front line on that discussion. Here to talk to us about the record of site condition itself, what it entails and what it means, is Madeleine Donahue. Madeleine heads the environmental department at the Toronto office of McLeod-Dixon, and she is a longtime environmental practitioner with experience both in-house and in private practice. This is really the meat of the sandwich in a lot of ways, because this package of legislation, the most significant part of it is the new reality of this record of site condition in the registry. So Madeleine, thanks very much for coming.
You're welcome. Good morning, ladies and gentlemen. It's a pleasure to see so many of you here in person and by webcast. Delighted environmental law is obviously alive and well in all of the practice areas. What I would like to do is, given that it's always a challenge for most of us when we attend a seminar to go back to our offices and actually read page by page the materials that were provided, I intend to stick pretty closely to the paper that I presented in the materials, obviously flying through it pretty quickly because I only have 20 minutes and it's a fairly detailed topic, the record of site condition. As Norm mentioned to you, the way I've organized my paper is I focused it really almost entirely on the provisions that are in force as opposed to the ones that will come into force next year. I've attached as appendices some extracts from the actual record of site condition regulation 153. In addition, I've also provided you with a download from the Ministry of the Environment's website, which is actually the pages that appear on the environmental site registry. The one thing that is not in the materials, I provided a handout just by electronic mail yesterday. There is a one-page flow chart for how records of site condition work, and I've sent that to the Law Society yesterday, and I think it may be available as a handout either later today or as a supplement. Oh, it's in there? That's great. But as Norm mentioned, the ministry has put out a very good, very lengthy guide dated October 2004 on the records of site condition, and it's quite a good guide. It's pretty hefty. It's not included in here, but it's just been recently posted on the ministry's website. So without further ado, let's get talking about records of site condition. What are they? Well, essentially, in a nutshell, a record of site condition is simply a document which is now prescribed by Regulation 153 and which describes the environmental condition of a property. In a nutshell, that's what it is. It is not a new document. Record of site condition has been around in Ontario since at least 1996, when the Ministry of the Environment put out its guideline for use of contaminated sites in Ontario, you know, the cleanup standards in Ontario. So we have the record of site condition there. So the incorporate, what is new now is that we have the record of site condition in some modified format now incorporated in a regulation, whereas before it was simply appended to a guideline which was not legally in force. Under the Environmental Protection Act now and the Ontario Water Resources Act, property owners who file records of site condition on the ministry's electronic website and follow the regulations for doing so and obtain acknowledgement from the Ministry of the Environment of that proper filing, what do they get out of it? Well, they get limited liability protection. Another speaker at this conference today will talk in much more detail about that, but the benefits to an actual filing is that your client, who's an owner of a property, and subsequent owners and other people in the chain can obtain some limited liability protection for ministry orders. And I use the word limited, and we'll discuss that a little bit more by other speakers later. At this particular point in time, as I think you've heard other speakers mention, whether you and your clients choose to file a record of site condition on the ministry's website currently is completely voluntary. And that's the scenario that it has been for the last several years under the guideline. The regulation does not legally require you to file a record of site condition. Now, as you have heard, in the fall of 2005, we don't know exactly which date, there will be provisions that are currently in the regulation where there will be mandatory filings of record of site condition. And those will be in connection with certain changes in property uses from a more industrial to a more sensitive land use. In circumstances where the Ministry of the Environment issues these new documents called certificates of property use, and also in circumstances where there are restrictions on the issuances of building permits in connection with a property use. So stay tuned for next year, because once they become mandatory, that'll be a whole new ballgame. But for now, it is purely voluntary. Let's talk about, I'm going to follow the format in my paper so you can follow along with it fairly quickly. Let's take a look at the record of site condition form. Don't look for the form as a schedule. Don't look for it online on e-laws or anything like that. It is not a form that is attached to the regulations, not to be found anywhere. The ministry will, in due course, I think, post an example on its website. When I last looked yesterday, the day before, it still wasn't there. But essentially, the record of site condition form is going to be a form similar, but with some variations to the one that we'd had before. It's going to be in an electronic format, and it's a much more detailed form than the one that currently exists in the guideline. When you're going to look at it, when the consultants are going to be going online and registering, inputting data for a record of site condition form, you're going to get the impression that this is much more complicated. It looks more complicated, it looks a bit different, it's set up a little bit differently, and it's much more detailed. Why? Because the regulation now prescribes the contents of what has to be on that form. So my paper on page 2 talks about there are a few new features to the record of site condition form, some new information that has to be provided. But essentially, as you'll see on page 3, there are 3 major components to the document. The first part is essentially what I call property information. The second part is what I would call environmental information about the quality of the environmental condition of the property. And the third are going to be attachments or supporting documents that will have to be provided to the ministry. Things like a survey or a plan, ownership, proof of ownership, those kinds of things. So who can file a record of site condition? What has to be included in the actual document? All of that is now prescribed by the regulation. Let's take a look just very briefly, as I mentioned, on the consequences of filing a record of site condition. If you and your clients choose, or other third parties require you to file a record of site condition and get a Ministry of the Environment acknowledgement of that filing, then what do you get out of it? Well, what you get out of it is that the Ministry of the Environment will no longer be able to issue certain environmental protection or Ontario Water Resources orders to people who previously had had the legal authority to do so under the legislation to address on-site contamination that was present when the record of site condition was filed. So basically, the owner who filed the record of site condition, if it's your client, subsequent owners, occupants, tenants after the filing, persons who have charge management control at the time of filing and afterwards, they basically will receive that limited liability protection. And I will leave it to the subsequent speakers to explain that to you in much greater detail. Let's take a look at the preparing a record of site condition. As I mentioned, it's purely voluntary, so you don't all have to rush out and tell your clients, oh, we have to get the record of site condition filed. The one thing that is important to note is many speakers have emphasized the increasing role of municipalities in these areas, and we have seen that in the last couple of years, and we're going to see that even more. Although at the moment filing a record of site condition is purely voluntary, your client may, if it is looking for development or application approvals from a municipality, they may find themselves in a situation where the municipality says, if you want this, fine, file a record of site condition. And so in a sense, although it's not legally required by the regulation currently, you may find yourself in a situation where you have no choice if your client wants to get the municipal approvals but to file it. So that is happening in some municipalities already. Time will tell. It's a bit of a patchwork around Ontario. There are, of course, and I'm going to page 5 of my paper, there are, of course, even when the mandatory provisions for the filing of a record of site conditions come into force, we think sometime in 2005, even there will be certain exemptions to the need for filing, and I'm not going to go into it, but it basically includes things like excavation or shoring work that you'd have to do. Obviously, you wouldn't have to file a record of site condition in those circumstances. Norm had mentioned that the regulation sets out 7 different property use classifications. The important to note is take a look at those definitions, because although they indicate agricultural, commercial, community, industrial, and so on, each of those are in fact then further subdefined, so you'd want to really look at the definitions. In the context of mandatory filings when they come into force, it's important to note that the regulation, and I'm talking about subsection 11.2 of the regulation, clarifies that the term change in use of the property means a change in the actual use of the property. So it's not just a zoning change that will trigger the mandatory filing of records of site condition. And in my paper on page 5, I've indicated certain other aspects that you want to take a look at in terms of whether you have a mixed-use property, for example, then it's the most sensitive land use category that will apply. Why is that important? Because the category of the property that you have will dictate really the kind of soil and groundwater standards associated with that property use. So it's important then to note the connection between them. The regulation talks about certain kinds of persons, and they define them. The record of site condition provisions of the Environmental Protection Act is all about the owner of the property. And it's important to note that the regulation, owner is defined in section 168.1 as a person prescribed by the regulation, and then when you look at the actual record of site condition regulation, it says that an owner includes a receiver. So those of you who do commercial work, that's important to note as well, because a receiver could find themselves in a position of wanting or having to file a record of site condition. Just from a practice tip perspective, one of the things that you want to be aware of is that if you choose, your client chooses, thinks it's in their interest to file a record of site condition in the context of a transaction, corporate commercial deal, a real estate transaction, or somebody is demanding that you do it, you've got to really give yourself the lead time in being able to get the record of site condition properly done in accordance with the regulation and so on. So bear that in mind when you're doing deals, the time frame that you're going to need to do, because always in these deals it's always much faster than you think, and now the process may be a little bit slower. Let's deal with the owner certification. One of the aspects that a record of site condition is there are two important aspects of the record of site condition other than the environmental condition of the property, and those are the statements associated with the record of site condition that must be made by an owner of the property and also by the qualified person, i.e. the consultant doing the site assessments for your client. Basically, a record of site condition requires that the owner or the owner's agent certify certain information that is prescribed in the record of site condition. And if you take a look at page 7, I've indicated the kinds of statement that the owner must make in the record of site condition. The owner must state, 1, that reasonable inquiries were conducted to obtain all information relevant to the record of site condition, including from any other current owners of the property. Let's say there's more than one. The owner must also say that all information relating to those reasonable inquiries that he made were disclosed to the qualified person. So he's given the appropriate information to the consultant you've hired. And third, that to the owner's knowledge, the statements made in the record of site condition are true as of the date that the owner or the owner's agent signed it. So I think from a practice perspective, you're going to have to go through those kinds of statements with your client and make sure that the client understands what that means to be able to be making those statements. In addition, the bottom of page 6, I've indicated that in addition to the statement made by the owner of the property in the record of site condition, there are going to be supporting documents that will have to be filed with the Ministry of the Environment's Site Registry Office in filing a record of site condition. Things obviously like the deed to the property, if there's a receiver in question, proof of the receivership. If there's an agent for the owner, then proof of the owner's appointment of the agent and authorization to sign for the owner and so forth. Then turning to the next, and as I say, we're going through this with lightning speed, qualified persons, the consultant statements. And I'm looking at part C of my paper, page 7 and 8. This is very important. The environmental consultant, the qualified person who is conducting the site assessments for you and preparing the record of site condition, is required to undertake certain activities relating to the filing of the record of site condition, and certainly one of them is making certain statements that will have to be signed off by them in there. Essentially, if you take a look at page 8, I've indicated that the qualified person then, in addition to actually filing a record of site condition on behalf of you and your client, has to certify, 1, that a phase 1, i.e. a non-intrusive environmental site assessment of the property, was done for the property in accordance with the regulation and under the supervision of a qualified person. So mandatory, if you're going to file a record of site condition, you must have a phase 1 site assessment. You can no longer just file a record. Second, the qualified person must indicate that as of the certification date, a phase 2 environmental site assessment is not required by the regulation for any part of the property, and in the consultant's opinion, it's not necessary to conduct one. So basically, they have to give an opinion that there's no need for a phase 2. And also, the qualified person must state that as of the certification date and in the consultant's opinion, there's no indication of any contaminants that are likely to interfere with any of the types of property uses that are proposed for the use of the property. So once again, those are fairly heavy-duty statements. There's nothing that's dramatically different in these sorts of statements, because many times in practice, up until now in any event, consultants have made similar sorts of statements in their phase 1 site assessments. They've put it in their conclusions, they put it in recommendations, but now you have a record of site condition saying, all right, the regulation now says if you're going to file one, you must make these kinds of statements. So for sure, I mean, careful consultants have always been careful when they're making these conclusions and recommendations, because they could be sued if they're wrong, your client suffers damages, but now I think because it's part of a regulation, it's going to be consultants will be even more careful in making these statements. In my paper on pages 8 and 9, I can't get into all of there are a number of other circumstances where there are other statements that will have to be made by the qualified person. For example, it's possible that on a large property, huge developments, that it could be that you have phase 2 site assessment reports done for only some of the property, but not all of the property. I have 5 minutes left. And so on pages 8 and 9, I've indicated to you the kinds of statements that a qualified person has to make. One thing to note again on page 9 is that in certain circumstances, although as I say it's a phase 1 site assessment that must be filed with a record of site condition, in some circumstances a phase 2 will be required, and that's, for example, if a property has ever been used for an industrial or commercial use, and also if the qualified person in their opinion says that a phase 2 is necessary, then a phase 2 will need to be done. Looking at section D of my paper, the list of reports, all of the reports that will have been done by the qualified person on the property, these reports are not filed with the Ministry of the Environment. The record of site condition simply lists all of the reports the qualified person has relied on in arriving at preparing the record of site condition. The regulation again prescribes how the phase 1 and phase 2 site assessments have to be conducted in accordance with the CSA standard. Page 11 in section E, the summary of site conditions, very important part, the meat really of the record of site condition in addition to the consultant statements. The record of site condition basically simply summarizes the environmental quality of the property, and it confirms through the statements of the qualified person that it's suitable for the proposed use. In turning to page 12, the site cleanup summary or risk assessment, in addition to indicating what the condition of the property is, as you know, there are basically two approaches to contaminated sites in Ontario. People will either do a cleanup, to what was then the guideline. Now it's going to be to the guideline that's been incorporated with variations into the regulation. Or you can do a risk assessment, and there may need to be some engineering done to make a property safe or not, maybe not. But essentially there are two approaches to that, and the record of site condition indicates that you're going to have to indicate which those are. Another aspect is that if for the property cleanup wasn't done, but a risk assessment was done which confirmed that there was no risk to human health or the environment or so forth, then basically the record of site condition says that the director of the Ministry of the Environment has to have accepted that risk assessment report that was submitted to the ministry. And the qualified person who's done the risk assessment has to make certain certifications with respect to the risk assessment as well. So I guess what you're hearing through over and over again is the qualified person has a lot of responsibilities in making a lot of certifications. I'm going to jump over section G. The important point to note in section G is that there is a certain quality control aspect that the ministry has now regulated with respect to soil and groundwater and sediment standards and so on. These are all now prescribed. There are also protocols for analytical methods, and again, this is more for your consultants to be aware of technically, but as lawyers you need to know that there are now regulated standards for carrying out these site assessments and for using qualified accredited labs, and again, these are issues that the consultant has to do. In the last couple of minutes, I simply want to touch on in item H, there are certain transitional issues. September 30th, 2004 was the deadline for filing any records of site condition under the old guideline process. From here on in, if you want to file one, you've got to follow the new regulation. One of the important issues is the ministry wanted to give the same sorts of protection to people who previously filed records of site condition now that are in the registry to ones who today, or effective October 1, will be filing. So they provided for certain transitional issues. Essentially, it allows property owners who previously filed records of site condition under the guideline to obtain an equivalent level of protection to owners filing under the regulation. So basically, they're allowing for the grandfathering. There is a transitional notice that would have to be filed, and again, a qualified person has to make certain certifications with respect to that. And there's certain criteria that must be satisfied, including that the ministry, first of all, had acknowledged the record of site condition and the guideline when you did it. The transitional notice is filed, and then the requirements of the regulation for filing and getting the same kind of limited liability protection for those older property owners also exists. In filing the record of site condition, and if you look at page 16 and forward, as I indicated, this is an internet-based registry system. It is accessed through the Ministry of the Environment's website. Again, it's for people to file records of site condition. It's for the public to get access to the records, and for other purposes that could be prescribed in regulations. Essentially, to file the record of site condition, the actual mechanics of it is that the owner has to have a qualified person who undertook a site assessment and demonstrate that the property meets the standards for the proposed use. The qualified person, if they haven't already done so, they have to get a username and a password from the Ministry of the Environment. And only when they get that can they then go online, register themselves as a qualified person, and the record of site condition is a document that's accessed by the qualified person electronically. So the consultant will do this online. Once it's completed, will download a copy for themselves, a paper copy. The consultant then has to get the paper copy to your client, the property owner. Property owner has to sign it. The paper copy and the supporting documents that I've described in my paper then have to be filed with the ministry's Environmental Assessment and Approvals branch. The important thing is that it's certainly possible for a property owner, once he has all of the documentation, to file directly and to bypass the consultant. But I think in practice, most people will simply have the consultant do the filing once the property owner has signed it. And essentially, the record of site condition filing is not completed until all of the supporting documentations are either mailed or faxed in to the Ministry of the Environment. The regulation then states that Ministry will do an administrative review to make sure that all of the paperwork has been properly done, in accordance with the regulation. And then from there, they then will allow the filing of the record of site condition to be registered on the electronic registry. And then the Ministry of the Environment is required to give your client an acknowledgement. And that acknowledgement is extremely important because it's really effective as of the date of that acknowledgement that your client receives that limited liability protection from future Ministry of the Environment orders, again, which will be discussed in greater detail. I think on page 18, on item 6, you'll see I've described in just a short paragraph the acknowledgement that the Ministry of the Environment must give to you if your RSC form has been properly completed. And finally, as with all things, the guideline process, as we've known it over the last several years, has certainly allowed the Ministry of the Environment to undertake audits of records of site condition that are filed. Well, that hasn't changed. Even under the current new regulation, the Ministry could choose to do spot audits of the records of site conditions that will be filed, and they could be paper audits, they could be review of reports, remains to be seen. I guess as a concluding remark, I can say to you is that the records of site condition could potentially, in the long term, particularly after the mandatory filing provisions come into force, over the long term, over many years, could be really quite helpful in terms of, again, it's another piece of a source of information for your client to do due diligence on with respect to the condition of a property. But it's not a panacea. And certainly under the guideline, I don't know the exact statistics, but there certainly wasn't an avalanche of records of site conditions that were voluntarily filed under the guideline. I'm not certain how much is actually existing in the database right now, but until thousands and thousands of pieces of documentation are filed in the registry, it may have limited use. So when you are looking at adding it to your due diligence checklist, if for property searches and so on, don't be surprised if it comes out that there's nothing. It's going to take time to build up a huge database. But certainly in the long run, when people get over the fear of all of these and the liability issues, and am I liable, am I making statements to people, I think it could be a useful piece of information, but once again, it's only one piece of information.
Thank you, Madeleine.
I hope I didn't go over my
Easy, isn't it? Thank you. That is, as I said earlier, a very significant piece of this Brownfields Amendment, and knowing exactly what needs to go into these records of site conditions, what it tells your client if they're the ones having the work done, what it tells you if you're searching it on the registry. It's obviously key. Adam Chamberlain is here to talk to us next about the piece of this puzzle that is probably changing less than any other part, which are the standards for cleanup, and these are for the most part what were known as the generic standards under the guideline. Adam has recently joined Aaron Burles, where he heads up the environmental group. He's a certified environmental specialist, and Adam, thanks for coming today.
No trouble. As Alex says, this is kind of the cleanup one. There's not a lot of change in this area, and so I expect to be brief and make up a little bit of our backlog. I'm somewhat more incentivized to do this because I'm moderating the last panel, and I want to keep every minute I can for that. So I'm going to get right to it. Under the guidelines that have been in use since 1996, the standards that we have found there have been known as tables A through F. These are standards that many people who have dealt with contaminated land, and frankly lots of people who have not dealt with contaminated land, will have heard of in real estate transactions and some other types of transactions. The most commonly referred to, in my experience anyways, have been tables A and B. Tables C through F are less commonly referred to, and frankly, people didn't read these things unless they were either consultants or suffering from severe insomnia. The new regulation provides for the soil, groundwater, and sediment standards for use under Part 15.1 of the EPA, published by the Ministry and dated March 9th, 2004. It's a standard. It's a document that, I don't know, it's less than a centimeter thick, and it's essentially a group of tables. There are some explanatory comments up front and later on, but it is essentially a bunch of tables. I meant to bring it up with me, I didn't, but it's a bunch of lists. They list elements, and then it'll list acceptable parameters or acceptable limits for those various different elements and substances. The unfortunate part to all this is, as one of the real estate lawyers in my firm mentioned to me the other day when I was describing this to him, is that this sort of nomenclature we've all been accustomed to, table A, table B, whatever, is gone, and we're now into a new regime where we have tables 1 through 6. You could be cynical and say that it's just to keep us all on our toes. There is a rationale for ordering it this way, and that it does, the ordering of these tables is now more in keeping with the EPA. Frankly, I'm not sure if I agree with the utility of making the changes, but nonetheless, we have them. And there are some changes. In my paper, you will see a list of them briefly. Table 1 is background soil, sediments, and water. That's a new one. New element of it. Table 2 is full depth, potable. Potable means for drinking water or water that could be consumed. Full depth, non-potable is table 3. This was formerly table B. And table 2, sorry, don't worry, I get confused which one's which, or which the concordance in any event. But tables 4 and 5 are the stratified, potable, and non-potable. These were formerly tables C and D. And table 6 is new in its soil extract and groundwater standards, and this is to be used to determine whether a site is a shallow soil property, which is an issue that has some significance when doing assessment of particular pieces of land. I'm not going to get into the description of when shallow soils are important, but I think my comments later on about consultants and your use of consultants will be reflected in that. If you don't understand it, you ask a consultant to make sure you understand what a shallow soil property is. In any event, given the rearrangement, we've got this new table, this new ordering, table 3 instead of table B, and table 2 instead of table A, and so on, and we'll get used to it over time. One notable change, or one notable change to the tables, and there aren't many, frankly. Most of the tables remain the same as they were, except renumbered, is the way that petroleum hydrocarbons are dealt with. This is gas, diesel, heavy oils, and various fractions thereof. There were two in the tables. There were two headings. One was petroleum hydrocarbons, gas, diesel, and the other one was petroleum hydrocarbons, heavy oil. What has happened now is we've moved to the Canada-wide standards for petroleum hydrocarbon, which is a good thing, brings us in more harmony with the rest of our provinces and the federal government, and we can all sing Kumbaya and be happy for that. It essentially means, though, that you've got, instead of 2 different parameters, you've got 4. And I've listed them out. Essentially, they go from, instead of having 2 where heavy and light, you've got various gradings of light to heavy hydrocarbons. There are some elements that are substances that are accepted from those that would normally be considered petroleum hydrocarbons. They're listed separately, and I won't get into them, but they are there. But essentially, the thing to note is that one of the things to note is there are separate notes at the end of these tables for interpretation. The notes, there are not very many of them, and I'm talking about at the end of the tables. These notes are important for the interpretation of the tables and are important for lawyers and for qualified persons. I'm not going to go into detail with respect to those, but there is some clarification with respect to various values for hydrocarbons, and I'll read you the note for it. It says, one of the notes says, for a site to meet the standard, and as I say, it's referring to hydrocarbons, there must be no evidence of free product, including but not limited to visible petroleum hydrocarbon, film, or sheen present on groundwater, surface water, or in any groundwater or surface water samples. The groundwater must be free of objectionable petroleum hydrocarbon odor and taste. This brings up an interesting issue. Odor and taste are not things that you can normally sense with equipment that labs use. These are machines. Odor and taste are obviously subjective. So I was at a presentation just recently where there was some discussion. We had a qualified person, I think he's a qualified, I trust he's a qualified person sitting beside me, and he was musing about the new job for engineering summer students that they'd have tasting and smelling these things. I pointed out to him that I thought it was arguable that the way that this is all framed, that is that the qualified person has to attest to these various standards being met, that perhaps this is not something that can be delegated and rather he'll have to do it himself. We had a little chat and mused about the fact that this might have some impact on the availability of health insurance for qualified persons. In any ways, it is something that's there. It's not a big issue, obviously. The one thing that is perhaps interesting about it is that for Table 6, the odor and taste requirement exists for potable and non-potable groundwater conditions. I think that was probably a misstatement because non-potable groundwater conditions generally indicate that nobody's going to consume the water, so why anybody would have to taste it is beyond me. This has been pointed out and written down in notebooks by various ministry people that I've spoken to, some of which may be here today. So we may see some fine-tuning of this, depending on how the taste goes. The implications of the amended petroleum hydrocarbon criteria is a little, perhaps less funny and will have a real impact. I'm not sure the extent of the impact, but because what's happened is with the two criteria covering the same spectrum of substances, hydrocarbon substances, there has been in effect a type of averaging. That is, if you had one type of hydrocarbon and another type, but they were in the same group, they'd get averaged out and combined in the measuring. Because this is being separated out into four, there's a few things that come to mind. One is that it apparently is going to cost a bit more to do this. There will be a slight increase in time taken to do these tests, although I suspect that'll get worked out. I've been told that they're more difficult for these tests to be completed, but again, they'll become de rigueur, and I suspect the difficulty will be dealt with just in a matter of time. But it will result in what one consultant described to me as improved recoveries. Improved recoveries is euphemistic reference to higher test results. So I think it's quite likely that we'll see more exceedances in petroleum hydrocarbons under these standards than we have seen under the guideline. It may not be a significantly higher number, it may not have a real impact, but it's something that consultants and lawyers dealing with it will have to watch for. The only other standards that I'm going to speak about is a reference to a standard in the regulation, and these are standards for the preparation of Phase 1 and Phase 2 environmental site assessments, and you've heard of these before. Now, and these standards have existed in the past, but now they're being codified essentially. These standards were developed and published by the Canadian Standards Association, and this is what some have referred to as a slightly inappropriate delegation of, well, I don't know if it's inappropriate, but some people have told me they think it is, delegation of this standard setting to the CSA. It raises some issues because it's not entirely clear whether the CSA will be having in mind these regulations when they might amend their standards from time to time, and it does, the regulation does allow for these standards to be amended from time to time, as you might expect. So there's some question as to whether this is appropriate, but frankly, I think it's probably the most pragmatic approach to this at this time, and the question will be, does it have any real impact? I'm not certain that it does, but it may, and it's something to watch for in the future, I think. One of the things we were asked to talk about today was a little bit of practice risk management, or issues related to practice risk management. I don't have a lot to say on that front, but there are a couple key messages to take away. One is that the change in the standards, as little as they are, may have some impact on the results, and it's important that any reports or analysis that are done on these projects be carried out in accordance with the new standard as opposed to the old one. I've already run into a situation where one consultant was referring to the old standard. We were very critical of that and concerned about it because of where we are now. It turned out that the consultant was referring to it, but the lab was employing the new standard. So in the end, we were fine. This is very recent, obviously, but it was one of these things that we caught, and I think we probably did a bit of homework for the consultant by forcing them to get their standard wordings in line. A lot of these reports, especially, many of reports I see start off as standard wording, so you may well see the guideline nomenclature and wording there. Hopefully not, but watch for it. It's important. If it ever did make a difference in the analysis or the conclusions at the end of a report, it could have some significance. And if not, its lack of clarity in what it's referring to would be potentially significant down the road. So watch that detail. The other thing I would say is that this is a technical standard. It is employed by engineers. It is interpreted by engineers, sometimes more than ought to be without the assistance of counsel, and at other times it is interpreted by counsel. So it is a technical standard, both from a legal and engineering point of view. It is something that many people don't work with, and one point would be, if it goes beyond a lawyer's area of competence, if you're getting into areas where you're not sure about what it all means or what the implications of what you're reading are, I think obtaining the assistance of a qualified lawyer, somebody who does this more frequently, or frankly, in certain circumstances, it may be that the appropriate consultant can provide you with the information you need on these standards. But they are available on the web. You can print them off. As I say, they're not terribly fun to read, but they're there. And the primary point I think I'd say take away from this is make sure that whoever you're dealing with is dealing with the appropriate standard.
Thank you, Adam. Gone are the days when we're going to be negotiating with U.S. Counsel that we do need guideline in the definition of environmental laws in Ontario. Luckily, it's now part of the regulation, and that'll make our lives a little easier. Thank you very much, Adam. We owe Adam an extra debt of thanks today because he's replacing his former colleague, David Crocker, who had a court appointment today. So thanks very much. We're going to take a break for about 10 minutes. A couple of cleanup items. Because this is being broadcast across the province, we're going to ask that you put questions in the boxes here in the front so that we can ensure that those are read, and those will be addressed at the end, so please do. The evaluation forms for the session are in the front of your program, and that helps us make sure that we provide good programming for you. We would like to ask Donna Shier and Michael Kovacevic to come up and take their seats so that we're ready to go for the next, and we'll see you in 10 minutes. Thanks very much.
Thanks, Adam. That's great. Yeah, that's super.
How about you? The lecture circuit like crazy, right? Sorry? You're also on the lecture circuit. Pardon?
It's going
The whole thing is terrific.
really well.